Hello, YouTube. I'm Vince White. I'm an employment attorney. My home office looks like it's been hit by a bomb because I'm packing for a ski vacation. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Safety Buddy, who asks us, or I guess ask me. There's not really an us, is there? Hello, Vincent. Can the statements from the defendants in one case be subpoenaed as evidence in another case? I am concerned that the rebuttal interview will be used to better prepare the opposition and enable them to cover their tracks and tighten loose ends as things continue. I'm being told that their statements will not be used as evidence in court. I'm being told that their statements will not be used as evidence in court for the case that they have submitted them for. They hang themselves with lies and contradictions on at least 3 separate points. Okay, I don't fully understand the question, but let's go with that first part of the question. You're like, hey, can the statements from the defendants, so can your employer's statements in some other case be used in your case? You say here, can they be subpoenaed? Yeah, you could subpoena them, but realistically speaking, they're probably going to be on a public docket. If these are things going on in federal court, that's a public docket. Almost everything will be publicly available. Often we do, as a firm, mine other cases by the same employer, right? If we have, let's just say like a Lady Ledbetter equal pay claim against an employer, whatever we'll call it, like Ernst & Young, just hypothetically. And we're saying, hey, we don't think this company pays women the same for the same level of work. At the same, similarly situated peers at the same level receive more or less money in salary depending on their gender. That's the basis of that claim, right? Well, let me tell you, we would absolutely look at the docket and try to find other cases against Ernst & Young that allege the same thing. And then we look at the discovery. We look at the summary judgment motions. We look at the motions to dismiss. We'd be looking at everything. Less the motion to dismiss, more items that are going to have like actual evidence in the arguments, like the summary judgment opposition, stuff like that. And we're going to look at how those attorneys in those cases proved their claim, or at least attempted to prove their claim, right? Whether or not they were successful doesn't mean we won't be successful. We still want the things they use as evidence, because as extensive as our own efforts might be in discovery, it doesn't, listen, if you have 5 attorneys thinking about the discovery demands on one case and chasing after what they want for that case, that's good. If you can double that and have 10 attorneys trying to get discovery out of a company to prove the same thing, well, that's better. You never know, right? I mean, listen, the absolute worst attorney might have the greatest idea on a given day, right? And also, I don't think any of these attorneys are the worst attorneys, right? The firms we're going to be looking at will generally be good firms, right? We're going to look at, where all the cases on this topic against this employer, and out of all the cases against this employer, we might prioritize firms that we think have a good skill set, a good pedigree. They do good work, right? If those firms aren't around, we might look at lesser firms that we think tend to be kind of like fuck-ups, but because there's still more people thinking about the case, right? And you can look at what they tried to get and what they argued a lot faster than it took them to make those arguments or get that discovery, right? So it still makes sense to review those items. I'm just saying realistically, if we know there's a firm who does amazing work and we see that they're litigating similar claims on a public docket, we're probably going to try to get that information. Now, you're asking a bunch of stuff here about rebuttals and can what you say in your rebuttal be used against you later. I don't know why you're being told it can't. I mean, whatever you talk about in your rebuttal or turn over in your rebuttal or attach an exhibit in your rebuttal, that's going to be stuff that they can get in discovery and run with as evidence, right? So, like, I don't know why you're being told it won't matter. It matters. It definitely matters. I think I just didn't understand maybe what your attorney was saying to you there or something like that. But I think the core of your question here is, can stuff from other cases be used in your case? Yeah, absolutely. Like, you probably want to see if you can get a hold of deposition transcripts. Because the deposition transcripts from other cases might be super amazing for yours. Just saying, you're having great thoughts here, and you're on the right path. Anyways, I hope this is helpful. If it was, like, subscribe, comment down below. It helps me to help more people just like you. Remember, almost everybody works, but not everybody wins. Be smart out there.